To order. Welcome to meeting number 17 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order referenced March 31st, the committee is meeting to study Bill C5 to amend the Criminal Code and the Controlled Drugs and Substances Act. Today's meeting is taking place in hybrid format. Pursuant to the House Order of November 25th, 2021, members are attending in person in the room and remotely using the Zoom application. The proceedings will be made available via the House of Commons website. For those using Zoom, your choice of language is at the bottom of your screen. You can either choose the floor if you can understand both English and French, or you can choose English or French. For those in the room, you can use the earpiece and select again the same desired channel, whether it's the floor, English, or French. And then just remember to push up the volume because it's usually on very low when you start on the house devices. Any questions from any of the witnesses? You can raise hands. I think you should be all briefed on it. Just we've had some technical challenges with some witnesses prior. Just some housekeeping. I'll show you a 30-second card when you have 30 seconds left in your time. So whether you're questioning or whether you're answering, just be mindful of that. And then when you're out of time, I'll give you a red out of time card. Hopefully try to wrap it up in there. I don't like being a stickler, but because everyone wants to ask questions, we have to be mindful of time. We will have, in the first hour, we have 3 witnesses. We have, as an individual, Beth Bui, a probation and parole officer. We'll have from Aboriginal Legal Services, Jonathan Rudin, program director. And from the Canadian Association of Elizabeth Fry Societies, we have Emily Coyle, executive director. I believe she's in person. And Nikki Kish, director, advocacy and systems change. So each group will have 5 minutes. So I'll begin with Beth Bui for 5 minutes for opening statements.
Good afternoon. My name is Beth Bui, and I have been employed as a probation and parole officer since 2007. I'm here to speak about my personal experience as a victim of sexual assault. Thus, my views and opinions do not represent that of my employer. I was born in Saigon in 1979. In 1985, my mother advised me that I was going to go on a trip with her. I was then just 5 years old. I recalled my mother holding my hand tightly as we ran through the rice field at night, trying to be quiet and not draw attention. I recalled walking through the swamp and being carried on the shoulder by an adult when the water rose too high for me to continue by foot. The boat we boarded was small and flimsy, and we were packed together like sardines. We were known as the boat people, fleeing Vietnam. For more than 10 days, we drifted on the open sea. We were robbed by pirates, but we were eventually saved. We stayed at a refugee camp, and it is here that my mother met a man, and they began a romantic relationship. After 9 months at the refugee camp, my aunt sponsored my mother and me to Calgary. Eventually, my mother decided to be with this man, and we moved to Brantford to reside with him, along with his sister and his nephew in a 2-bedroom apartment. As an immigrant, my mother worked 2 jobs, sometimes 3, which was mostly at night, and the man worked during the day. This created opportunities for this man and his nephew to take advantage of me sexually. I was a young child, being just 8 years old, unable to speak English and not knowing or understanding what was happening to me. Before this incident, I viewed the world as an adventure. Afterwards, the world became a dark and frightening place. In 2011, in my early 30s, I became a mother, and I realized I can no longer live with this secret. In order to ensure my child's safety, I must report the 2 perpetrators to the police. The first perpetrator was found not guilty in criminal court. I cannot identify this man due to a non-disclosure agreement in civil court, but he continues to reside with my mother to this day. As a victim, the criminal court process left me wounded inside and invisible on the outside. As for the second perpetrator, He left the country and there was a warrant for his arrest. At first, I hesitated to meet with Mr. Larry Brock in preparation for this case. I honestly felt that the 1 hour and 30-minute drive in rush hour to Brantford was not worth my time for a 5-minute face-to-face meeting with him. Mentally, I was preparing to hear why my case was insignificant, that I would not find a reason to not trust Mr. Brock to do the job of protecting me as a victim. It is what I have learned and expected. I was ready to be dismissed and defeated. However, Mr. Brock proves me wrong. In 2019, the perpetrator was found guilty at youth court in Brantford. He received 6 months house arrest, followed by 6 months probation. The offender was a few months short from being an adult during the commission of this offense. Due to the offender reporting his address in Brampton, which is where I'm living, I felt it was best not to access counseling and resources close to my home. I felt that my choices were limited and I felt alone. I feel that I do not deserve the label as a survivor because I feel that I'm not surviving. I still view myself as a victim because the sexual abuse is devastating. It is shameful as a mother to admit that I do not want a child who is a girl because I know the challenges that she may face too well. It is crippling to constantly question whether I'm a good mother for my children. It is exhausting to unlearn past behaviors and relearn healthy ones. I feel that the offender's lenient sentence negated my lost childhood, my self-worth, and my potential. Ultimately, I feel I was not supported by the criminal justice system and continue to view myself as a victim even to this day. Thank you.
Thank you, Ms. Bui. I can imagine it's very brave of you to have come forward with your own personal story, and there's no words I can share to give you my heartfelt sympathy in sharing this. And I think Rely, along with all the members, are very thankful that you've been very brave to come here and share your story. So please do recognize that we all want to hear you, and we all share the pain that you've gone through yourself. Next, I will ask Mr. Jonathan Rudin from Aboriginal Legal Services to take 5 minutes for opening statements.
Thank you very much. I'd like to thank the committee for the opportunity to speak about Bill C-5. As I begin my submissions, I want to note that while the English name of our organization is Aboriginal Legal Services, our Anishinaabe name, given to us by Elder Jackie LaValle, is Gakinagwai Waba Madibwewan, and this translates as all those who seek the truth. As the legislative summary makes clear, a major impetus for the introduction of this bill was the case of Sharma. ALS was involved in this case since it began in 2016. We wrote the Gladue report for Ms. Sharma. Shortly after completing the Gladue report, at the invitation of Ms. Sharma's counsel, we intervened in the case at the Superior Court of Justice and led the calling of expert evidence and arguments on the charter issues. We were successful in having the particular mandatory minimum for drug importing struck down as cruel and unusual punishment. We also intervened at the Ontario Court of Appeal, where the restrictions on access to conditional sentences were found to violate the equality rights of Indigenous people and the right to liberty under Section 7. And we recently intervened at the Supreme Court in the PPSC's appeal of the Court of Appeal decision, and as you know, that case is now on reserve. I was privileged to be able to act as lead counsel for ALS throughout. While we are, of course, supportive of this bill, it must always be kept in mind that if it passes as written, all it will do is partially restore Canadian criminal law to where it was in 2012. All of the work that was done in Sharma and all of the work of this committee just brings us back to where we were 10 years ago. And while this is certainly necessary, it is hard to see this as representing progress. And we need to be clear. What is happening to Indigenous people in the criminal justice system today is mass incarceration. In their paper, Criminal Justice Reform and the Mass Imprisonment of Indigenous People in Canada, Jane Sprott, Cheryl Webster, and Tony Dubes studied non-Indigenous and Indigenous rates of incarceration per 100,000 of population. In 2017-18, the non-Indigenous incarceration rate was 79 per 100,000. That represented a 20% decline from 1996, when the legislation creating conditional sentences in Section 718.2e was passed. In contrast, the Indigenous rate was 677 in 2017-18, a 33% increase from 1996. Indigenous Canadians are now almost 9 times more likely to be imprisoned than non-Indigenous Canadians. And when the 2017-18 rate of Indigenous incarceration is compared to that of the US, the Indigenous rate is actually slightly higher. America is the leading example of mass incarceration in the industrialized world. The fact that Indigenous rates are even higher than the US means that mass incarceration is the only term that can adequately describe what is happening to Indigenous people. And this fact is a national disgrace. This government promised in 2015 to implement all the recommendations of the Truth and Reconciliation Commission. One of those recommendations was to abolish mandatory minimum sentences and the restrictions on conditional sentences. Bill C-5 is a start, but only just a start on this commitment. We believe this is likely the only opportunity Parliament will have to enact meaningful changes to mandatory minimums and conditional sentences. It is important then for this committee to be brave and to be bold, and to proactively address the other mandatory minimums in the criminal code not expressly addressed in Bill C-5. We know that the other mandatory minimums have not been studied in depth by the House, but that is not going to happen anytime soon. An option that has always existed and that we urge on this committee with respect to all other mandatory minimums is to do what other countries have done and allow for what are called safety valves. A safety valve can be used by a judge who is concerned that the imposition of a mandatory minimum sentence will cause serious injustice to the particular individual before them, and to exempt that person from the mandatory minimum without having to declare the minimum sentence unconstitutional. The advantages of such an approach are twofold. First, it is quicker than having to challenge the constitutionality of a mandatory minimum and leaves the legislation in place for most offenders. And second, decisions of trial judges are, of course, subject to appellate review. Within a few years, we would have a robust set of jurisprudence on what sort of cases merit the use of a safety valve. Introducing an amendment to permit judges to rely on a safety valve for other mandatory minimums is a necessary and positive step forward. Miigwech, Niawe, thank you.
Mr. Rudin. Next, for 5 minutes, if I can have the Canadian Association of Elizabeth Fry Societies, and you may split your time accordingly, but you have a full 5 minutes between the two of you.
Thank you. I hope you can all hear me. Great. So thank you to the committee for the invitation to attend and provide testimony today. Our organization works to address the persistent ways in which women and gender diverse people who are impacted by criminalization are routinely denied their humanity and excluded from conversations of community. Even the use of the word offender, which is throughout this legislation and in common parlance, serves to separate the people that we work with from being considered as part of the public in public safety. Our head office is located on unceded and unsurrendered Algonquin territory, and our organization, along with the Women's Legal Education and Action Fund, which is known as LEAF, and the Black Legal Action Center, known as BLAC, have jointly submitted a brief to you, which you will already have seen, hopefully, detailing our 5 areas of interest in this bill. As you are all very much aware, this bill seeks to reduce the structural racism, systemic discrimination, and inequality that we know is a crisis in our justice system, which has been acknowledged at this committee by several witnesses and even by the Minister of Justice. We also recognize this bill as a step toward that goal, although it does not go far enough, as Jonathan Rudin has stated. I also want to acknowledge Beth for sharing her story at the outset. It was really brave, and I thank you for that. Today, we would also like to offer context into the human and social impacts that we see within this crisis. And I will turn it over to my colleague, Nikki.
Thank you. Part of our work is to monitor the conditions of confinement in the 5 prisons designated for women across the country. It is there we meet the people who have been harmed and who continue to be harmed by existing legislation. The majority of these women and gender diverse people face complex mental health issue and unresolved addiction that properly belong in the healthcare, not prison system. If and when they are released, their unresolved issues will be compounded by the strong stigma which follows those with criminal records. When you walk into a maximum security unit in these prisons, you will see that they are full of Indigenous women, gender diverse people, and two-spirited people. It is a sobering fact, one that should make us all take pause, that 50% of all women and gender diverse people in prisons in Canada are Indigenous. In these prisons, we meet so many Black and gender diverse people whose neighborhoods have been over-surveilled, criminalized, and ultimately failed by multiple systems, and who end up being overly punished by our legal system. In these prisons, we meet the countless survivors of sexual and physical harm, dispelling the false dichotomy that continues to be raised around perpetrators and survivors of violence. It is also in these prisons that overwhelmingly we meet women and gender diverse people who are simply trying to survive poverty for themselves and for their families, who often cannot afford food, electricity, clothing for their children, and their vital needs. Lack of judicial discretion to depart from required sentencing put them there. Legislation that does not recognize the discrimination which impacts their social histories put them there. And so we presently have a system that punishes through a debunked perspective that increased punishment for certain crimes through mandatory minimum penalties will deter people from participating in those crimes. Yet the implicit social messaging we are giving in Canada through the adverse impacts created in mandatory minimum penalties is that if you are poor or from a marginalized community, you are undeserving of a fair chance, undeserving of rehabilitation.
Back to our brief that we submitted to point to 5 solutions that we have proposed. The first one is to remove all mandatory minimum penalties. If that cannot be done, at least those that have been found to be constitutional already by courts across this country. The second, we recommend that you remove the bar on conditional sentences for any offenses with mandatory minimum penalties. The third, fulfill the Truth and Reconciliation Commission of Canada's call to action 32 to allow trial judges, upon giving reasons, to depart from mandatory minimum sentences and restrictions on the use of conditional sentences. And we refer you to Senate Bill S-213 for suggested language on this amendment, which I believe you've heard of already. We also suggest to amend Section 718.2E of the Criminal Code so that sentencing judges will have the information required to pass appropriate sentences not only for Indigenous defendants, but also for Black defendants. And at the very least, fully decriminalize simple drug possession as a step toward the recommendations made by the group behind decriminalization done right, and provide for automatic expungement of criminal records for simple drug possession, which is certainly a step toward the spent record regime, which we, along with 84 other organizations and people, are members of a coalition called the Fresh Start Coalition, and that is what we are recommending. And so, in conclusion, I think that you have all seen that the breadth of evidence demonstrates that incarcerating people, especially women and gender diverse people, in the name of deterrence is not only a demonstrably failed model, but actually produces harm, especially by adversely impacting Black, Indigenous, and low-resource women and gender diverse people. I think it would be irresponsible to ignore the clear evidence on these impacts, and I will just finish now. We remind you, that behind each devastating statistical figure that you've been hearing about attributed to racial and socioeconomic overrepresentation in our justice system is a human being with a family, with a community, all who are being adversely impacted in ways not contemplated within this law, and we know those individuals. We know their stories, we know their histories, we know their pain.
Thank you, Ms. Coelho. You're going to have to finish off in one of the questions, so I apologize for that.
It's fine. Thank you very much.
Our first round of questions will begin with Mr. Brock for 6 minutes. Mr. Brock.
Thank you, Chair. And thank you to all witnesses, but in particular to Ms. Bouey. Ms. Bowie, thank you so much for accepting my invitation to attend this particular study. And like the chair, I offer my sincerest thoughts about your background and what you had to go through. It brought me back to the day that I first met you for the first time and hearing your story. So thank you for that very powerful message and the strength that you have shown in attending here today. Beth, Bill C-5 eliminates the mandatory minimum penalties for 14 very serious firearm offenses and drug offenses such as trafficking, importing, and production for drugs such as fentanyl and crystal methamphetamine. Since it's apparent that there has been no reduction in the number of offenders who are committing these offenses across this country, while there are still mandatory minimum penalties, as a resident of the GTA who is married with children, do you feel that this bill will compromise your sense of safety and other members of your community? You're on mute, Beth.
Sorry. The answer is yes. The reason being is I live beside a park, and ever since the law has been lax on marijuana, there has been a rise in criminal activity in the park. I see people using and dealing drugs from my window. I see them speeding away while impaired. And this is happening during broad daylight when the children are outside playing. The world has become dark and scary.
Thank you, Beth. Bill C-5 eliminates the barriers of conditional sentence considerations for some very serious offenses, such as kidnapping, human trafficking, criminal harassment, and sexual assault. Adult offenders who commit these heinous crimes can now argue post-conviction that they should serve their denunciatory sentence in the comfort of their own home. As I described to you in my former capacity as a Crown attorney, prosecutors have a very low success rate in securing criminal convictions in this area. Coupled with a significant, long-lasting, if not permanent trauma associated with this crime, it's no small wonder why there is underreporting to law enforcement. What kind of message does this send to victims of sexual abuse? And had you not come forward when you did and reported your experiences, would you have done so if Bill C-5 was now the law in Canada?
If Bill C-5 became law, I do not think that I would report my sexual abuse because I would feel my fight would be futile. For example, the offender in my second case, he was free to live and he was free to live his life while I felt like I was in prison because my choices were limited in the same community where I lived.
Thank you. Your opening statement, Beth, describes a very tragic and difficult time in your young life. Bill C-5 makes no provision for the rights of victims in the criminal justice system. How would you describe your experience as a victim in the system from the perspective of your relationship with the police, the Crown attorneys, victim service agencies, and the judiciary?
Overall, I feel that I did not have a positive experience. The female detective that was on both cases was not empathetic to the trauma, to my trauma. The Crown attorney in the first case seemed distant and uninvested. The victim services were helpful, but I had so many different workers. It took almost 10 years for the matter to be resolved. And the judge seemed to not consider my trauma and harm caused. My saving grace was you, Mr. Brock. For once, I felt heard. I felt like I mattered. And I felt like I could trust someone.
Thank you. To Mr. Rudin. Mr. Rudin, it's good to see you again. I've enjoyed your presentations in the past as a member of the Crown Attorney System in Ontario. You've identified that this is a small step in the overall impact of over-incarceration. In terms of the numbers are real, that there is still an extremely high percentage of Indigenous offenders adult and youth, male and female, who are committing the type of offenses that Bill C-5 attract. In addition to this type of legislation, are there other areas the federal government ought to be considering in terms of reducing that number?
I think there are a number of initiatives that are important, and I know that the submission from Elizabeth Fry Society talks, for example, about information available to judges to come up with proper sentences. And so one of the challenges that is faced by Indigenous people across Canada is the GLADU reports, which you, Mr. Brock, will be familiar with. They're very familiar in Ontario, but in, for example, Manitoba and Saskatchewan, they're not available at all. And while the provision of those reports belongs to the province as part of the constitutional rules for administration of justice, the federal government could do more and is starting to do more to provide funding to allow for these sorts of reports to be prepared by Indigenous organizations.
Thank you, Mr. Rudin.
Thank you, Mr. Brock. Next round of questions will be from Ms. Briard for 6 minutes.
Merci beaucoup, Monsieur le
Thank you, Chair, and thank you to all our witnesses who are here today with us. Thank you, Ms. Bui, for having shared your testimony. My question is for the Canadian Association of Elizabeth Fry Societies, either of the witnesses. Even in 2020, although they represent only 5% of the adult Canadian population, adult Indigenous people represented a very high proportion of imprisoned individuals in Canada. And the correctional investigator of Canada told us that Indigenous women represent half of the imprisoned women in Canada. Are these factors, what are the factors that have contributed to this overrepresentation, rather? And would you agree that mandatory minimum penalties and restrictions on conditional sentences have contributed to this situation? Thank you.
Thank you very much. The reasons for the over-incarceration of Indigenous people, and in particular Indigenous women and gender-diverse people in our prisons, are multifaceted, and certainly the justice system has its role to play. We must go back hundreds of years to look at the assimilation practices of the state, including residential schools, the 60s scoop, the millennial scoop, our current practices around child protection services, the many ways that Indigenous communities are over-surveilled by police, by social workers, by schools, and then, all the way up until they reach the justice system, they are already underserved and over-surveilled or over-policed. However, once we reach the justice system, certainly mandatory minimum penalties and the lack of availability of conditional sentencing, as Mr. Rudin pointed out, all of the arguments that were made in Sharma have contributed to the over-incarceration of Indigenous women and girls. And I have to tell you, if you go to the prisons in the prairies, particularly where people spend most of their time, which is in the provincial jail system, 90%, upwards of 90% to 98% of the people there are Indigenous. And it is a failure, and it is extremely shameful. We need to consider them when we are thinking about the word public and public safety. Thank you for your question.
Merci beaucoup.
Thank you very much. I now have a question for Mr. Rudin. I'm the Parliamentary Secretary for the Minister of Mental Health and Addictions, and obviously the opioid crisis is something that concerns me greatly. The government recognizes that the problematic use of opioids is a health issue, and we're working very hard to ensure that drug users are diverted from the justice system and are instead steered towards support services and healthcare services. In this spirit, C5 would modify the code, amend the code, to eliminate mandatory minimum sentences for certain offenses. Would you agree that alternatives to substances offenses would be a good idea?
Thank you for the question. There's no question that many of the individuals who are involved in a low-level drug trafficking and drug possession cases are themselves addicts. And jailing them does not work, and we know that from our work. We operate and have operated since 1991 a criminal diversion program, which takes on people who have drug offenses as well as other charges. And there's no question that if people are going to address their substance use, they're not going to do that in jail. What they're going to do in jail is they're going to take more drugs or other drugs. So I think C5 is a step in the right direction. I will say that I don't know that we really want to be criminalizing people at all who are using drugs, and we certainly, our brief to the expert task force on substance abuse was to decriminalize the use of drugs. C5 talks about enhanced diversion, and I will just point out that in our discussions with the Toronto Police Service, they're saying that there's going to be a price tag for these sorts of things. And so I would just urge the federal government to consider, as C5 goes forward, that things will actually be in place to allow the provisions that the bill permits to actually happen on the ground, because the division of powers in this country makes what seems to most people to be very simple things actually very complicated.
Pensez-vous que
Do you think that the police have the tools they need to implement these new standards?
I can only speak to the places where we have programs, and I think, yes, there are programs out there, but there does need to be a commitment. If the expectation of police are going to release individuals to programs, that there are programs out there. And so again, the question of funding becomes pretty crucial.
Merci.
Thank you.
Selon vous,
Ms.
quels
Briard.
seraient
Thank you, Ms. Briard.
les six...
What are the
Time has run out.
Thank you. Sorry.
Next 6-minute round, we'll go to Monsieur Fortin.
And Mr. Fortin now has 6 minutes. Thank you, Chair. Thank you to our witnesses for being here, and thank you, Ms. Bouy, for your very moving testimony. Clearly, you've gone through something that you shouldn't have had to go through, and I sympathize with you entirely. I have a few questions for Ms. Coyle. Ms. Coyle, and thank you also for being here. I heard your testimony with regard to the data and the high numbers of Indigenous women in prison in the Western provinces, a majority proportion. I'd like to know about the reasons why this situation exists. I understand that we think that mandatory minimum sentences may be at the root of it. There is, however, the possibility of a Gladue report being submitted for every single case so that Indigenous women have more appropriate sentences. And there are also perhaps support services available to Indigenous communities that could be used upstream before incarceration. If we eliminate mandatory minimum sentences but don't do anything else, then I'm not sure it's the right approach. I'd like to hear you then on Gladue reports. Do they not help or at least diminish the problem of Indigenous women in prisons?
718(2)(e) of the Criminal Code, which is what we usually refer to when we're talking about Gladue reports, as Mr. Rudin has already said, are unavailable in many parts of the country. And there aren't, many things that are in principle do not follow in practice. And so certainly we would not want to eliminate Gladue reports. We think it's an excellent first step. But we have to step back a little bit and realize that all of the actors who contribute to the criminalization of Indigenous women have their part to play. And it's really important that the justice system recognize that they can't step back and say, you know what, we're going to pass the buck. This isn't our responsibility. We can't claim that it's our responsibility. In fact, it is the responsibility of the justice system vis-a-vis the ways that we overly punish people, in particular Indigenous women and gender diverse people. And that is why we are here today, along with our colleagues with whom we submitted the brief, to speak about the fact that mandatory minimum penalties do overly impact Indigenous women.
Je m'excuse, Madame.
I'm sorry, Ms. Coyle. I don't want to be rude, but my time is limited. So I understand from your testimony that Gladue reports are a good thing, but you say they're not available in certain regions, in many regions, for example, the West. Would the solution then not be, or one solution not be, to fund the training of people who could draft Gladue reports?
More funding would definitely be welcome for many people who are seeking Gladue reports. And particularly, you need the courts and the Crown in those areas of the country to recognize that they're valuable and that they bring valuable information to the court.
Are you telling me that there are Crown prosecutors in the West who don't think Gladue reports are useful? That's right. All right. Then I think there's perhaps work to be done to explain the usefulness of Gladue reports, to have them accepted both by defense and prosecutors. That is, there would need to be training of interveners who could then draft these reports, Gladue reports in each case. That would help reduce overpopulation of Indigenous women.
Extended to include Black defendants as well. We should look to a similar type of pre-sentencing report that could be provided for Black defendants.
And so if we look upstream, obviously the Gladue report only comes at the moment of sentencing, but if you look further up, so upstream, so before all this happens, I understand that there's the Black community and perhaps other communities that could be included, but let's talk specifically about the Indigenous community. I think you represent them mainly. If we want to prevent these Indigenous women from being prosecuted for their behavior, could there something not be done earlier? For example, through better socializing work or community work to prevent violence, for example? Is there something that could not be done to prevent offenses?
Particularly when it comes to Indigenous women and gender diverse people, not individualize or locate the responsibility in the person, but look at what we need to do as a society to address, anti-racism, anti-Indigenous racism. We need to look at colonial practices and really there's a lot to do with financing, certainly. Funding, yes, I agree. Thank you. Sorry, I'm out of time.
Thank you, Monsieur Fortin. Next to Mr. Garrison for 6 minutes.
Thank you very much, Mr. Chair. And I want to start by thanking Ms. Bouey for her testimony and say that as a fellow adult survivor of child sexual abuse, I have a bit of a understanding of how hard this is to do. And I think your testimony is very important in the way our justice system fails victims. And our committee has a study going forward on that. And at the appropriate time, I'm going to ask that your testimony be brought forward for that study. My first question I'd like to ask to Mr. Rudin, he raised, I think, an important point. This bill will expand access to conditions, but in fact, will that make a difference for those who live in rural, remote, or Indigenous communities? Will they actually be able to avail themselves of conditional sentences? Are the resources actually available?
So thank you for the question. It is a very important one. It is true that in some communities, the resources that might be necessary are not present. I think we don't want to assume that just because it's a small community, an Indigenous community, a reserve community, that there are not resources there. But certainly one of the concerns I think a judge will have is they will say, well, how are we going to enforce, for example, house arrest, or how are you going to get the programming that you need if it's not available in your community? So yes, I think that while it's important to have those options available. Again, this has to be tied to increased resources to allow for these conditional sentences to actually be implemented.
Thank you for that. I want to turn to the Elizabeth Fry Society, and one of the things, Ms. Coyle, that you raised was for us to focus on the individuals and the impacts on individuals of incarceration. Could you talk a bit more about what happens in terms of housing security, employment security, child custody to women who are incarcerated?
I'd like to invite my colleague Nikki to perhaps answer one of these questions as well. Nikki?
Thank you. I think that the reality is devastating and one that many are not familiar with. We see very poor outcomes pre, during, and post incarceration, not only for Indigenous, marginalized, and gender diverse people, but for their communities. Certainly the prison system is overwhelmed itself by these overrepresentations and incapable, despite often its best intentions, of facilitating a meaningful family contact, reintegration supports, employment supports, and the things we need to build strong communities. So as we're working on the ground level to resource our communities and to work preventively and post-incarceration, we're hoping through this that we can just revert to a more responsible law that can be informed by social context and then respond to the needs of everybody impacted by crime.
And we see that mandatory minimums often result in short sentences served in provincial institutions. Maybe, Ms. Kish, can you talk about what resources for rehabilitation or treatment of addiction or those kind of things are actually available to people serving those short provincial sentences?
Unfortunately, almost none. Across the country, remand centers are notoriously deprived of rehabilitative services. They're structurally violent places where people are essentially kept in cages for most, if not all, of the day, where the food quality is very low. People have very limited access to the phone, to the law. And what we know, because we've been living in the system, is that this outcome not only produces detrimental results for the people who experience these systems, but for community and society broadly. If we want safe communities, we have to build transformative justice that cares about the needs for all.
One of our previous witnesses talked about that a lot of the conflict of justice system is of course, a legacy of colonialism in the residential school system, but they noted that the over-incarceration of women in a not very ironic, I don't want to use that word, but in a very direct way, perpetuates that intergenerationally, that it inflicts damage on kids in particular because of their mothers being incarcerated. Is that something that you are seeing?
Emily, did you want to jump in? Okay, I can speak. Oh. Sorry, it is. Go ahead. It is something that we see. Unfortunately, I don't mean to laugh at any of this context. It's devastating because we see people who are transferred, especially right now, from the prairie regions with the highest overrepresentations of incarcerated people to the Atlantic region, where people are completely isolated from family and community, which was not the purpose of the regionalization of the women's prison system.
And I just wanted to add, if you walk into a prison designated for women in this country, you will find that the visitation areas that are generally full, if you go to the prisons designated for men, are empty. And often there are no opportunities or resources available for the children of the people who are in those prisons to go visit. We do have a mother-child program in the prisons designated for women, which is largely underutilized, and in my opinion should never be utilized. We don't want children in prison. In fact, you know, there's in a lot of ways we would like anybody who is parenting to not have to serve their time in prison, especially if they have the main parenting responsibility for their family.
And so would the expansion of access to conditional sentences then help address that problem?
Yes, in our opinion, it would. Was I heard? Yes, it would.
Sorry, Mr. Chair, I think we're having a little internet problem here, perhaps on my end, so I'll just end my questioning there.
Yep. Thank you, Mr. Garrison. I think she just had a simple one-word answer, so that might have been it. Next, for 2 rounds of 5 minutes, we'll go to Mr. Moore for 5 minutes.
Thank you, Mr. Chair, and thank you to all of our witnesses for appearing today. Ms. Boy, thank you for your sharing of your personal story. I know that that must be very difficult, and I think it's important for us as a committee to hear from victims of crime. Often we do not hear from victims of crime enough, and certainly appreciate you taking the time to share with us your story today. According to the criminal code, one of the main objectives of sentencing is to promote a sense of responsibility in offenders and acknowledgement of the harm done to victims and to the community. And you've shared with us your experience and the experience in your community. What message do you think it does send to victims if, for very serious crimes, we do not impose some form of incarceration on the perpetrators? I think you're on mute.
Sorry, I think the victim would, for me, I would feel not important. Like my rights is not being considered.
Okay. And what do you think Parliament should be focused on when it comes to gender-based violence? If more house arrests and conditional sentencing is not the answer, I guess what message does that send to Canadians, and particularly women and girls? And as well, what do you think Parliament should be doing instead of reducing the sentences for some of these crimes?
I would like more accountability. I would like to be heard. I would like to be seen. And I think that's what's missing in the victims of these cases.
Yes. Okay. Thank you. Oh, go ahead.
It's just a struggle for me from day one. I feel like I had to fight the system. I had to struggle to be heard from the police, the crowns, not the first crown. And when I was on the stand, I feel so little. I feel like I didn't exist.
Okay. Well, we do appreciate you having your voice heard here today in a parliamentary committee. And I'm sure you're speaking on behalf of the feelings of many victims throughout our country. Mr. Rudin, I have a question for you. You mentioned something that we should all acknowledge, but when you mentioned it, I think it's something that we really need to take note of, and that is Canada is multi-jurisdictional, federal, provincial, and municipal, all with components of either responsibility or the impact on when it comes to our justice system. And as you know, the federal government, we have carriage of the Criminal Code, Controlled Drugs and Substances Act, but you mentioned the importance of resources on the ground if we're going to make changes. And we've heard testimony from others saying, you know, whether it's parole, whether it's conditional sentencing, ensuring someone is meeting their conditions, that resources are stretched thin. So when we make a change here in Ottawa at the federal level, it has a downward pressure on other jurisdictions. Can you elaborate on that a bit to maybe share some of your thoughts on what groundwork should be laid or resources should be put in place when we're making these type of decisions? Oh, sorry, you're on mute, sir.
Thank you. We're still getting used to it after 2 years. So yes, so thank you for your question. I do think it's very important that when the federal government starts to bring in legislation such as Bill C-5, that there is funding available to the provinces to be able to create the programs that are necessary. The federal government, the Department of Justice, is generally very good in providing often funding. It's a timeshare arrangement or a cost share arrangement with the provinces. So the provinces have to want to be involved too. And that just needs to be considered. But if a province is obstreperous and refuses to put the funding in, then it creates a real problem in which, in our case, Indigenous people end up suffering the most.
Okay,
Thank you. Thank you, Mr. Moore. Next, for 5 minutes, Ms. Diab. Ms. Diab, we can't hear you. You're not on mute, but it might be your headset plugged in or not. Maybe there's a... No, still can't hear you. It might be, there's a button on your headset. No, still can't hear you. Maybe unplug it and plug it in again, the wire.
Is that any better?
Yes, now we can hear you.
Wow. So
Perfect.
sorry about that. Thank you
No
very
problem.
much for all our witnesses and for whatever few minutes I have left. Apologies for that. I have a question for the Elizabeth Fry Society. As a young person, many years ago, as a law student, actually, I got introduced to the Elizabeth Fry Society here in Nova Scotia. And through that, and that was decades ago, so I can only imagine now, I saw all the good work that is being done on the ground here and across the country for particularly for women and now, gender diverse people. So Ms. Coyle and Ms. Kish, you've made a point a few times that we need to have a criminal justice system that accounts for systemic racism as applying Gladue principle does for Indigenous people. And we've previously heard about the role that race and culture assessments in sentencing can play in addressing the systemic racism in our justice system. What do you think of the use of those assessments? And is that also part of what we can pursue to advance racial justice? And what else would you recommend? And please go ahead and take your time, either one of you or both of you.
Nikki, I'll turn it to you.
I think, working together across tables is really important so that we can recognize and bringing people's voices in, bringing everybody's voice who's impacted, both through the law and through our programs and our services, because right now through mandatory minimum penalties, we're having so many people across Canada who are kept and broken from their families in permanent ways. We're having outcomes that we're sure that Canadians would be very concerned with if they knew. And we believe that if authority is given to the justices and parole officers and correctional authorities to meet their mandates and incarcerate or not incarcerate and return to community people when they're ready, that this will have the strongest result. Emily?
Yeah, and to answer your question specifically about Gladue reports or similar type reports for other people, there is a utility to them. There is certainly a utility to anything that is able to bring to light the various factors that have brought a person in front of the justice system or involved with the justice system. And the thing that you will uncover in these types of reports are the very things that we mentioned at the outset, which is, for example, in the prisons that we go into, the people that we meet are survivors themselves of violence, many structural violences, but also physical, sexual, emotional, financial violence that they've experienced in their lifetimes. And then we punish them again through our legal system. And so the legal system is complicit in the type of violence that they are experiencing. And so I think if we're able to utilize those types of tools to bring to light the stories of the people that are being brought forward in front of the justices, it can be very helpful.
So just following up on that, would you would recommend a rehabilitative approach for people who've committed a crime and don't pose a threat to public safety instead of imprisonment? I guess, can you tell me what kind of rehabilitative approaches would you recommend, and why do you think it's a good thing to do? I know you've already talked about it, but if you can elaborate a little bit more on that. And how is that different from your perspective across the country?
We often work with people who, have never gone to school, have never been in social positions where they've had access to career development, to social stability. And so we see people wanting to contribute to society and wanting to succeed and wanting to be a part of the common good, but not feeling stuck. Increasingly, we're seeing people passively go through the justice system without understanding the laws that are impacting them. And then this process, we're seeing cold, hard prisons that create worse outcomes. And then people are returning to the community without any access or pathways toward meaningful participation.
Thank you. And again, I just want to restate that the mandatory minimum sentences here that are at play, that are in this, is provided that there is no threat to public safety. And so you would agree with that?
Thank you. Thank you, Ms. Kiss. Thank you, Ms. Diab. Next, for 2.5 minutes, Monsieur Fortin.
Monsieur Fortin for 2.5 minutes. Thank you, Chair. My question is for Ms. Coyle. We don't have a lot of time, but I'd like to hear you. You've been speaking about Indigenous women in prisons, but who were themselves victim of violence, rape, assault, and so on. These women who are victims of such crimes, do they not want their aggressors to be in prison?
Necessarily speak on behalf of everyone who has experienced that. However, I can say that we have an inquiry into missing and murdered Indigenous women and girls in this country. We have the Truth and Reconciliation Commission findings in this country, and many of them speak to the fact that people who are Indigenous in this country have suffered many types of violence. And so, whether or not somebody is looking for accountability through the lens of imprisonment or looking for accountability and healing from many different systems, I think is a larger conversation.
Thank you. But, well, I understand that the perpetrators, men or women who are in prison, would like to see mandatory minimums eliminated. But I'm wondering if a woman who's a victim of a violent act, extortion with a firearm, etc., if we say, well, let's get rid of the mandatory minimums, then the person who's perpetrated that crime with firearm would not be required to serve a mandatory minimum. What would be the reaction of these women?
Specific people's reactions, but I will say this. If we are really looking to achieve public safety, and we are not achieving it with the system we have now, why are we not trying to pour resources into a system that would achieve true public safety? And mandatory minimum penalties are not giving us that.
Thank you.
Merci. Encore du temps?
Oh, I still have time? I haven't finished? I've got more time, Chair?
Okay. Merci, Madame.
Thank you, Ms. Coyle.
Thank you, Monsieur Fortin. Next, for 2.5 minutes, to Mr. Garrison.
Thank you very much, Mr. Chair. I want to return to either of the witnesses from the Elizabeth Fry Society and talk about a knock-on effect here of the over-incarceration, which is the large number of Indigenous women in particular who have criminal records. And can either of you talk to us about the consequences you see for trying to rehabilitate and reintegrate people in their communities who have criminal records?
I really thank you for that question, because I think I was only able to touch on it very briefly in my remarks. We are part of a coalition of 85 organizations and individuals called the Fresh Start Coalition. And if any of you are interested, we have a website, and we have many testimony on that website of people who have criminal records. A criminal record follows a person for the rest of their lives, and we have currently a very onerous application system that people have to go through in order to get their record suspended at the end of a certain period of time. So the length of time is long before a person can apply. The application process is onerous and can be expensive, despite the first step of reducing the initial application cost, which was just done recently here in Canada. So I think that you know, for us, for people who are coming out of prisons with criminal records, it can affect their housing. So they can't find homes because of a box on a landlord's questionnaire. They can't find employment because employers, in fact, we have an example recently that Nikki can speak to really briefly, if you would like, of a person who lost her job.
Yeah, unfortunately, we work with an individual who was released after lengthy incarceration. They spent many of the years inside the penitentiary doing the best that they could, helping others, doing the best that they could from the place that they were. And when they were released, they found meaningful employment. And then an old internet article that was found by their employer caused them to be fired from their job for the disclosure of that. So we see over the life course criminal records significantly barring people from rehabilitation and meaningful employment.
Right now, the bill as it stands does not include expungement of those criminal records. So it's the obvious question here: what positive impacts would that actually have if we could add that to this bill?
Well, I mean, our system is mandated toward successful rehabilitation and reintegration. So I think that we ought to equip ourselves as a society to provide that. And when people are sanctioned through incarceration and then sanctioned again for the rest of their lives through prevention of the social determinants of wellness, the expungement.
Thank you, Ms. Kish. Thank you, Mr. Garrison. That concludes our first panel. I want to thank all the witnesses for your testimony. It's always very informative and very powerful, and in Ms. Bouey's case, very emotional and personal. So I want to thank you. We'll now suspend for a few seconds or a minute or so while we do a sound check on the next witnesses, and then we'll resume right after that. For 5 minutes, and as I had said earlier, I use cue cards. Just when you're down to 30 seconds, I'll raise a yellow cue card, and when you're out of time, I'll raise a red one. So I don't like interrupting when you're in your thought, but the 30 seconds hopefully gets you enough time to wrap up your train of thought. So we'll begin with for 5 minutes for Ms. Durham.
Good afternoon, Mr. Chair, and thank you for facilitating this discussion. A couple years ago, I received a call from one of my commercial tenants about a fence of mine being cut, stolen goods around the area, and a storage shed that was being used by addiction and drug use. They also had a shelter behind one of the units with illegal drug paraphernalia scattered around the area. Not knowing any better, I started to clean it up and watch the situation. This group of people were gathering behind my property on city land in an area known to RCMP. Many stolen bikes, goods, and our tenants were getting broken into regularly. I started to take pictures, documenting things. One night around 10:30 p.m., I got a call from a friend that the fire department was down on my property. I rushed down, worried about the fires because the units were loaded with potato chips, and our neighboring property is low-cost propane. The fire department stopped me at the gate and warned me not to approach this group. They were known to police and dangerous, especially when high. The fire department recovered 11 needles that night, and the city sent a hazmat team into the area to recover the drug paraphernalia on their property. I told City Council if something doesn't change and a fire gets into low-cost propane, Cranbrook is going to light up like the 4th of July. From that point forward, I became more vigilant in my attention to the situation, recording things, emailing bylaw, reaching out in hopes that some form of government could help. I started to share my story about being broken into in my own home one night. It was a night I was going to leave my 15-year-old son home for the first time. Call it mother's intuition, but I drove into town late that night and picked him up. That night, someone entered my home. The police knew this person. My son's PS4 was stolen and loose change taken. A few weeks later, after obtaining fingerprints off my window and video surveillance from my neighbor's property, who also had his car and shed broken into, the perpetrator was arrested. 8 other people whose homes were broken into that were blacklisted out on the court documents. And then I was invited to the court case, but declined out of fear of safety for myself and my family. Since then, I was on Facebook where I noticed another business had issues and was reaching out. She mentioned issues with drugs, threats to employees, and theft. Things were getting crazy for businesses. A few businesses met with MP Morrison and City Council. I told them I represented 4 businesses, all victims of crime, employees that had knives pulled on them, and goods stolen. Our local garden center offered to purchase razor wire for these businesses. Over 100 businesses came forward. We are a town of just over 20,000 people, and commercial crime is up 171%. There was a young employee who, for her first job, had a gentleman come buy goldfish. When he was paying for the goldfish, he dropped drug paraphernalia all over the cash register. The man then proceeded outside to open the bag of goldfish and eat them live in front of this young lady. I leave you with the thoughts of your family home being broken into, your young son home by himself, your daughter having to watch someone eat a live goldfish. We, the law-abiding citizens, are being targeted by crime and violence, knives, machetes, while trying to protect our families, our businesses, and our livelihood. Removing mandatory minimums would only give these criminals another avenue to escape penalties and continue to be victims of the hardworking people. Thank you.
Thank you, Ms. Durham. Next, for 5 minutes, we'll go to Pierre Brochette from the Association des Directeurs de Police de Québec.
Mr. Brochet from the Quebec Association of Police Directors. Hello, thank you, Chair, and hello, everyone. I'm also the head of the Laval Police Service with some 400,000 inhabitants in our town. I'll give you a few examples of events that have recently taken place on the Laval territory. On the night of May 7th to 8th of this year, there was a murder from a moving vehicle, through a moving vehicle rather. There was a birthday party, and the driver as well as a child were killed. A 14-year-old was hit and will have serious consequences for the rest of their life. The perpetrator was not known to police. The very next day, 10 shots were fired in a residential area at 2 p.m. in the afternoon. They were fired at a multi-unit co-op, housing co-op. Obviously, this created a lot of insecurity in the neighborhood. And the very next day, so that was 3 days in a row, on May 10th, there was an attempted murder with firearm, once again in a residential neighborhood. 2 young women were nearby, only a few meters from the firing. They were looking for their cat that was below a car, and they suffered post-traumatic shock. In all 3 cases, there were not only direct victims, but there was the creation of a terrible sense of insecurity in a residential neighborhood, a very, very great sense of insecurity and not being safe. We all understand the situation of overcrowding in the prison system and the overrepresentation of Indigenous people and visible minorities. But we believe that if minimum mandatory penalties are eliminated, we're only addressing a symptom and we're not going to the source of the problem. For serious crimes committed, those in particular committed with a firearm, to maintain trust in the justice system, we believe that there must be serious consequences for the perpetrators. We would like to emphasize the articles of the criminal code, the sections of the criminal code related to firearm use. First of all, the use of a firearm or fake firearm in the commission of an offense, which is Article 85. Second, discharging a firearm with intent to wound, maim, or disfigure, Section 244, or discharging a firearm recklessly, 244.2. These are 3 offenses that have been very common recently. This is the 3rd year in the Montreal region that we've had double the number of shootings or discharge of a firearm on the territory. This is creating a great deal of insecurity on the territory and among police services. We do have a proposal. The 2015 Supreme Court of Canada Noor case and the 2016 Lloyd case, also from the Supreme Court of Canada, proposed solutions. One was a derogatory clause that would allow minimum sentences to be maintained for firearms-related offenses, but would allow judges in certain situations to not take into account the minimum mandatories and instead to opt for another type of sentence that would allow overrepresentation objectives to be met, and yet at the same time there would still be exemplary sentences or denunciatory sentences for serious crimes. The Association of Police Directors of Quebec would like then that minimum mandatories be maintained for firearms-related offenses. Thank you.
Thank you. Thank you, Mr. Burchett. Next, we will go to Catherine Latimer of the John Howard Society of Canada.
Thank you very much, Chair and committee members. It's a great pleasure to be here before you to share John Howard Society's views on Bill C-5. For those of you who don't know about the John Howard Society, we're a not-for-profit that is committed to just, effective, and humane responses to the causes and consequences of crime. And we have about 60 offices across the country serving communities. We fully support the policy objectives underpinning Bill C-5, but we feel that they have not gone far enough. So I just want to take you through some of the ones that we specifically would like to raise. One is the cautions, warnings, and referrals to programs. It is often the case that that it is more timely and more effective to deal with alleged criminal offenses through cautions, warnings, and referrals to community programs. It's not unusual for people to call the police when they see someone struggling with a mental health issue or an addiction issue, in the hopes that by calling the police, they will enable the person to get the help that they need. In effect, what happens is that it leads to the criminalization of the person and further involvement in the criminal justice system, and allows for the long-term discrimination of having a criminal record. What these proposed amendments will do is allow for individuals with substance abuse issues to be referred to community programs where real assistance might be available. These measures entrust the police with important discretion, and as the types of these conditional sentences. The mandatory minimum penalties is of great concern to the John Howard Society of Canada. We're long-standing advocates opposed to mandatory minimum penalties, which we consider to be always unjust when the proportionate and fit sentence in the circumstances is less than the prescribed minimum penalty. Certainly, there is nothing in a reduction or an elimination of mandatory minimums which would preclude the courts from awarding the penalty that is appropriate and fit in the circumstances if it's more than the mandatory minimum. So it doesn't affect serious offenses by eliminating the mandatory minimums. If there is a reluctance to remove all mandatory minimums immediately, and I take Mr. Brochette's point that his organization is comfortable with having what Jonathan Rudin described as a safety valve. We have long urged that there be some discretion added to give judges the opportunity to impose other than a prescribed mandatory minimum penalty if it's needed to achieve a fit and proportionate sentence. So we would agree with the l'Association des Directeurs de Police de Québec and others who you've heard who would urge that there be judicial discretion to allow for something other than the proposed mandatory minimum penalty. And we think that without a measure of judicial discretion to impose a fit sentence where a mandatory minimum is prescribed, the GLADU provisions and some of the other mechanisms that are intended to allow for a cultural context to have an impact on the sentence will have little effect. Minister Lametti indicates that he hopes these provisions will address and reduce systemic bias in the system. We hope he's right. We think that it is one small step towards looking at a very significant problem, and we think a lot more needs to be done. So in conclusion, the John Howard of Society of Canada supports the general direction of Bill C-5, but urges the committee to amend the bill to provide judicial discretion to impose other than the mandatory penalty to achieve a fit and proportionate sentence, require the collection of data to assess whether the provisions are having the desired effect of reducing racial inequities, and consider a broader application of the diversion and conditional sentencing provisions. Thank you very much, Chair.
Thank you, Ms. Latimer. I'm just going to use my chair's discretion. I'm going to reduce times by a minute for the first round. So instead of 6, we'll go 5-minute rounds, and the second round will go 4 minutes instead of 5, and the last one will go into 2 minutes rather than 2.5. And hopefully, I'll be able to catch up on the time. And if we need, we may go over for a few minutes. I'll get the consent of my members, but we'll see that closer to. So over to you, Mr. Morrison, for 5.
Thank you, Mr. Chair, and thank you for the witnesses on a Friday afternoon. Appreciate your input, especially on such an important bill like C-5. Mr. Thank you for being here today, and I know it's hard for an individual to come before a parliamentary committee and do a speech and that. So I really appreciate you being here today. And what's important, I think, for us in the committee is to understand the differences sometimes between rural and urban. And if people haven't really been exposed to some of the rural challenges, it's nice to hear, from someone who comes from a smaller community like Cranbrook. And I'm well aware of the issues Cranbrook is having, the challenges with assaults, with vandalism, with break and enters and arson, and the fact that it almost seems as though it's a bit of a revolving door with the local police who have their hands tied in being able to do any kind of incarceration. So it's basically the same individuals continually committing the same offenses. And it's 2.5 years ago, Cranbrook was a community where people would move to raise their children because it was safe and fun. And of course, it's in the middle of the Rocky Mountains, so it's a pretty beautiful place. But today, it's changed dramatically. Crime increase has been huge. The opioid crisis, like everywhere, a lot of places in Canada, is spinning out of control. And of course, the opioid overdoses are frequent, if not every day. I do know too that you might not be aware, the city mayor and council brought in the British Columbia Attorney General to address the fact that the small communities are not designed to handle some of these issues that come along with the opioid crisis and with the violence, where a smaller police force and I'm sure our Quebec police officer can attest to this, they just can't handle the challenges in small communities that we have. So the Attorney General, of course, said that it was a federal problem with Bill C-75, which is catch and release, and threw it back at the federal side. But I'm wondering, you bring not only as a victim, as an individual, but also as a business. And talking to a couple of businesses, one problem is that when they get repetitive break and enters, the amount of damage that's done is so much that now, where they used to donate $50,000, $60,000, $80,000 to nonprofit organizations, all that's money is going into repairs and trying to build back their losses. I wonder if you could comment on that for a second.
Yeah, I totally agree with you. I think that it's come to the point where we're spending our money on fixing our fences. Even yesterday, I had 2 incidents on our place. One, that they've cut our fence again, and there was a fire. I was called by one of our tenants on that in the morning, and then in the evening, I was down there to find a vehicle parked on our property, and when I called police, they wouldn't go with me. So here I am under one of my sheds by myself, having to check to see if somebody's in my lot or what they're doing there. The vehicle looks like it's somewhat abandoned. I understand the person is currently in hospital. It's another drug-related incident here, but yeah, we're not even allowed or able to support our local food bank right now because we just can't afford to anymore.
Yeah, and just so you know, some of the C5, this bill we're actually discussing right now, is looking at conditional sentences for a lot more offenses, such as drug trafficking and assaults with weapons and things like that. So I'm wondering if I realize that Cranbrook does need some assistance with, especially with rehab and with helping the addiction issue, but it also, do you think that the victims have been sort of left behind and it's all about the offenders?
Yeah, for sure, 100%. Actually, I feel like these businesses. One of my tenants has 2 properties, and they're getting $3,000 worth of theft on one property and a couple thousand on the other property, and our insurance claims are a lot higher than that. So we're just taking a beating, and the police are overrun with this. I mean, they've done a good job. Like, in my opinion, they've done a good job, but there isn't enough of them, and we're having to take this on ourselves. And I've been warned very carefully by both police and the fire department not to approach some of these people. They're dangerous. The one guy's carrying a machete around Cranbrook. There's other businesses, same thing, broken into.
Thank you so much, Mr. Yep.
Thank you, Ms. Morris, Mr. Morrison. Next, we have Ms. Dillon for 5 minutes.
Thank you, Mr. Chair. My questions will be for Ms. Latimer. In your opinion, how do mandatory minimum sentences delay court trials, and how can we mitigate this type of, delay?
There's little doubt that having mandatory minimums actually slow down the court process, and there's enormous backlogs now because of COVID. So removing as many mandatory minimums as you can should ease some of the pressure on the court system. And the reason why it delays the court processes so much is because people don't want to plead out. They can't plead to something less. Because the mandatory minimum is fixed there, and so they have a tendency to want to contest and plead not guilty rather than go by route of some sort of arranged settlement for something less than what they're charged with, which is often the way it goes when there isn't a mandatory minimum.
Thank you. And to those who don't impose a threat to public security, would you actually, instead of having them imprisoned, maybe recommend rehabilitation? And if so, why, in your opinion, would that be good or bad?
Yeah, I think the evidence is fairly clear that a custodial penalty is damaging in terms of rehabilitation and reintegration. So if you can hold someone appropriately accountable in the community, it is far better to do it that way because they maintain their links with housing, they can maintain their links with any kind of treatment that they're undergoing, they can maintain their links with employment, and if you come out of prison, you generally come out in a poorer state of mental and physical health than when you went in, often without provincial health care coverage, so you've got some significant challenges in terms of locating health care. And unemployment is a big problem, as well as being released into homelessness. So generally, people who are having to discharge their measure of accountability behind bars are facing a lot more problems.
Okay. And can you speak to conditional sentences? We heard from the Elizabeth Fry Society, and they spoke a little bit about this. In your opinion, conditional sentences, do you think it's better to let somebody back into the community or just, put them in jail and throw away the key?
I think it's 1,000 times better if they're not a threat to public safety to keep them in the community with a conditional sentence, which is a custodial penalty. So as soon as they violate one of the conditions, public safety is protected because of how quickly they can be placed behind bars. But if they're in the community, it instructs them and guides them and coaches them towards more pro-social conduct. So they can be facing curfews, they can be facing a great number of stringent conditions. And if you can get them to adjust to that lifestyle, you're well on the way of supporting rehabilitation and more effective reintegration and greater community safety in the long run than if they had been in prison and released without the supports.
Okay, and mandatory minimum sentences, as we know, are a one-size-fits-all approach. In your opinion, how is this very harmful to those from the Indigenous community, the Black community, other marginalized communities? How can such sentences be harmful to them? Are there aggravating factors and mitigating factors? If you can please explain.
I think the challenge with mandatory minimum sentences, particularly for Indigenous and Blacks and others, that if there are provisions like the GLADU provisions, which allow you to look at the historical and social determinants which have led the person to be in a circumstance that might predispose them or might lead them into criminality, none of that can be considered as a mitigating factor in terms of allowing them to have a less serious consequence if you have a mandatory minimum penalty. So it completely eradicates the GLADU provisions and anything that could be done for Black people or other people if you don't have that latitude.
Okay, perfect. How many minutes do I have left? 20 seconds?
15 seconds.
15. Well, thank you very much for coming today.
Thank you. Next to Monsieur Fortin.
Mr. Fortin, you have 5 minutes. Thank you, Mr. Chair. My question, well, first of all, I'd like to say thank you to the witnesses. I interrupted you just now, Ms. Latimer. Sorry about that. Thank you to Ms. Durham and Mr. Brochet as well. Mr. Brochet, I'm delighted to see you here today as the head, as an active chief of police, rather. Your opinion will count quite a bit with regard to firearms and crimes in general. You're in Laval, just north of Montreal, and you've seen an increase in the number of firearm crimes in the last few months. Laval has seen shootings rather. So I'm happy to hear you today, hear what you have to say. From what I understand from your testimony is that eliminating mandatory minimums is not a good idea. Why? Because you need to send a clear message to the population. And you're also of the opinion that perhaps a specific clause would allow to compensate for the disadvantages of mandatory minimums. I'd like to hear what you have to say on this idea of a message. The message sent to the population, for example, your population in Laval, that lived with these shootings in their neighborhood. The idea of eliminating mandatory minimums for crimes carried out with a firearm, discharging a firearm with intent to wound, using a firearm in the commission of another offense, fraud, and so on. What is the message being sent to the Laval population? Answer. I think this message would be very negative if mandatory minimums were eliminated. This is the third year I've said then that we've seen the number of shootings on the rise. We think this is a trend that will continue because there's now a firearm culture in Laval. We know that younger and younger people are using firearms. There have been more illegal firearms seized, a higher number of firearms seized, and the police always have to be on their guard in case a person is carrying a firearm. As for the citizens, having spoken to many inhabitants of Laval, they are feeling very unsafe right now. And what's happening is that someone is going into a neighborhood such as the St. Rose neighborhood and firing at housing where there may be a family living. The idea is to score points as a member of a street gang. I mentioned the events that happened earlier this year, and people have been saying, we're planning to leave the neighborhood. So the idea that Canada would want to pass an act to eliminate mandatory minimums, I'm sure that the citizens wouldn't see this in a positive light. Objectively, if we eliminate mandatory minimum penalties, that doesn't necessarily mean that the court would make sentences any lighter. The judge could continue to impose harsh sentences, but also, in certain special circumstances, give less than the mandatory minimum. As a police officer, as a police chief, do you have any worries that the judges will simply hand out light sentences? Or do you think that the problem is really one of messaging to society? Answer. Both are concerns for me. First of all, there's the question of the message sent to society. As a society, Canada does not encourage firearm possession. This is a situation, we didn't used to be a country with a lot of firearms. That's changing. But my other concern is that there will be too much discrepancy in sentences. Sometimes defense lawyers do what's called judge shopping. They'll look for the judge who's the most favorable to their case. And so sentences may vary greatly depending, or somewhat, depending on the judge's philosophy. I'm sorry. I've only got another 15 seconds. I just want to hear what you have to say about the firearms. Are these illegal firearms or legal firearms in the crimes that have been perpetrated? Answer. Most times we're talking about illegal firearms. Thank you, Mr. Brochet.
Thank you. Thank you, Monsieur Fortin. Next, we have Mr. Garrison for 5 minutes.
Thank you very much, Mr. Chair. And my questions will be to Ms. Latimer from the John Howard Society. And I want to start, of course, by thanking the John Howard Society for the enormous work it does in helping reintegrate those who serve sentences all across the country, helping actually future victims. We hear a lot about deterrence. And I guess my first question, Ms. Latimer, would be, in your experience, what deters future crime? Is it fear of severe punishment? Is it fear of getting caught? Or is it actually getting successfully reintegrated into society?
I haven't heard the last one evaluated, but I will tell you that it tends to be the fear of getting caught, which has the effect of deterring crime. If they're likely to get caught, they don't want any part of it. And it isn't the severity of the penalties. I mean, most people, a lot of the prisoners that I've worked with, their expectation was that they weren't going to get caught, and if they were going to get caught, they'd take the hit. But their expectation and hope is that they're going to do this and not get caught. So if they were going to get caught, they wouldn't do it. Yeah.
And I guess in a lot of the discussion, there seems to be a presumption that somehow we serve victims better by heavy sentences rather than focusing on rehabilitation. And in the experience of the John Howard Society, what would you have to say to those folks?
I think when you are working with people who have been on a criminal path and you can get them off a criminal path and towards a more pro-social contributing lifestyle, you actually are preventing victimization. There's a lot of people, if they've been successfully rehabilitated and are being reintegrated with supports, who will not reoffend. More can be done there, but I think a significant amount can be done and is being done to reduce victimization.
And I know you said you support the expansion of the use of conditional sentences. Do you share the same concerns we've heard before, that those tend to be under-resourced in rural, remote, and Indigenous communities?
I think it is a significant concern. I know that when you have community-based conditional sentences, you really are hoping that the community has the resources to be able to support those. And many dysfunctional communities or under-resourced communities, I guess is probably a better way to describe it, will be producing a lot of friction and are likely to be more crime prone, but they may not have the community-based resources to be able to really provide very good conditional sentencing alternatives and programs. So I think it is important that some resources be supporting those sentences.
And what currently is the role of the John Howard Society in the enforcement of conditional sentences?
There used to be a lot more conditional sentences before they were repealed, and so John Howard's role has changed because there has been a real drawing back of conditional sentences. But we work with people who are in conflict with the law in order to try and help them get on the right path. And it's frankly much easier if there is a community conditional sentence than if there is a custodial sentence, because they do not get alienated from things like employment and housing, which are big challenges when people are coming out of prison. And the actual prison experience itself can be very traumatizing for people and have a negative effect on them.
And I'm going to ask you the same question that I asked to the Elizabeth Fry Society, and that's about the impact on families of incarceration as opposed to conditional sentences.
Yeah, it can be very difficult. A lot of the males, for example, who are placed in custody, tend to be the contributing to the household and the income of the household, and so their families, when they're removed from that role, tend to get slid into poverty and survival mode, which is very challenging for them.
And one of the things that I've got very little time, let me ask you very quickly, is about the role of criminal records in obstructing rehabilitation.
Devastating, I would say. People are not protected from discrimination on the basis of historical criminal offenses until they get a pardon or a record suspension, and even then people can check things out on Google. But if they have a pardon, which is not all that easy to come by, it's expensive, it's a convoluted process, and it's in desperate need of reform, not as many people are applying for that as should be. And John Howard is a strong member of the Fresh Start Coalition that Emily spoke about, which we would hope to ease that. But you have raised also...
Thank you, Ms. Latimer.
Sorry.
Thank you, Ms. Latimer. Thank you, Mr. Garrison. Next, for 4 minutes, we have Mr. Cooper.
Thank you very much, Mr. Chair, and thank you to the witnesses. I'm going to address my questions to Mr. Brochette. Bill C-5, Mr. Brochette, in addition to eliminating mandatory jail time for very serious firearms offenses, also eliminates mandatory jail time for serious drug offenses, including trafficking and the production of Schedule 1 and Schedule 2 drugs like heroin, cocaine, fentanyl, and crystal meth. As a chief of police, does this concern you?
As a police chief, I'm aware that drug use is really a public health issue rather than public safety issue. We're very aware of this. We don't think that we should claim that possession and use of drugs is something that should be taken lightly, but
just to interject, I want to be clear, this bill is not about possession. We're talking about trafficking, we're talking about the production, we're talking about the drug dealers and the drug pushers, the people who are putting this poison out on the street that are killing Canadians every single day. Just to be clear in terms of the substance of the bill.
Yes, that was the second part of my answer. So the first part is that, yes, possession and use shouldn't be taken lightly, but we don't think that the sentences should be reduced for trafficking. Trafficking is a plague in our society. Organized crime is very, very active in the sale of drugs, drug trafficking. That's how they earn their money. And that leads to other crimes as well. People will perpetrate crimes to be able to obtain drugs. So we don't think that sentences should be minimized for drug trafficking.
Component of Bill C-5 is the expansion of conditional sentencing for very serious offenses, including sexual assault, kidnapping, human trafficking, arson for a fraudulent purpose. I'd be interested in your thoughts on that as a police chief.
Well, as a chief of police, I've seen here in Laval that there was a real problem with sexual exploitation here in Laval. There was a lot of minors who were caught up in this web and exploited by unscrupulous people. It's clear that this type of crime and the crimes that you've mentioned should be severely punished, and it could the message could be sent, a very difficult message would be sent out to victims if there were conditional sentences for perpetrators of this type of crime.
That when we're talking about these types of offenses, that all this would do is allow nonviolent offenders to serve their sentence out of jail. But when we're talking about some of these crimes, I don't think we're talking about nonviolent offenders. Would you agree?
Indeed, the number of offenses and the seriousness of the offenses in this act is worrisome. We would like to see firearms prioritized in the act because that's a very serious problem. But of course, we also have sexual trafficking, and we need to worry about the impact on victims.
How much time do I have, Chair?
You have 40 seconds.
Okay, and I would just ask the chief if he has anything further to add, other than that this bill sends a bad message.
No.
No. Well, I've said what I wanted to say. We have concerns about armed violence. Thank you for letting me say what I wanted to say on behalf of all police directors in Quebec. This crime must stop, and we must do something about this issue and get the message out that we will not accept this type of armed crime.
Thank you, Mr. Cooper, and thank you, Mr. Rochette. Next, we'll go to Ms. Briard for 4 minutes.
Ms. Briere, you have 4 minutes. Thank you, Chair. Mr. Brochet, I'm listening to your answers. It's not because we're abolishing mandatory minimums that there wouldn't be strong sentences. It's if you don't trust judges to impose proportionate sentences.
That your mic is not selected. If you can check on your screen, if you go to the mute, the little arrow beside the mute button on the screen, and just make sure you've got your headset picked and it's not the mic from the...
Pouvez-vous, s'il vous plaît, vérifier que vous avez bien sélectionné votre micro?
Est-ce que c'est mieux, Monsieur le Président? Is it better now?
Is it better, Mr. Clerk?
Unfortunately, no.
No.
Pardon?
No.
Now?
No.
Pardon me. No, the sound isn't good.
I'm going to ask you if you want to just unplug and plug your headset in.
Okay. Can you go to the... Okay,
Next
can
speaker?
you go, Mr. Chair, to the other one, and I'll come
Sure.
back after?
I will go to Monsieur Fortin for 2 minutes.
Monsieur Fortin, you have 2 minutes. Thank you.
Yes. Mr. Moore?
Yeah, I mean, it's after 4. I know some of us have things we have to get onto. So what time are you planning to wrap up? I know we're
It would
scheduled to go
be
to 4.
6 more. Ms. Briard was for 4, and there's 2 2-minute rounds, so 10 minutes, if that would be okay, if the will of the committee. Just because we had that sound issue for approximately the same time.
Yeah, I'm going to have to step off. So can we wrap in like 6 minutes, like 2 and 2?
We can do that. I hear a nod. If I see nods, and Ms. Briard can also do that in 2 minutes, or if she doesn't, we'll get somebody in the office. So we'll go to Mr. Fortin. Yes.
I think on our side we'll be willing to forfeit our round.
Okay. So we'll just go to Monsieur Fortin and Mr. Garrison for 2 minutes each. So Monsieur Fortin.
Mr. Fortin, you have 2 minutes. Thank you, Chair. My question is for Mr. Brochet. Mr. Brochet, we've heard a lot about over-representation of, in particular, Indigenous women and Indigenous people generally and racialized people in our prisons. In some cases, this overrepresentation seems to be due to mandatory minimums in the criminal code. I don't agree with this assertion, but I'd like to hear what you have to say. Do you think that by eliminating mandatory minimums, we would have a lower representation of certain types of people in prison, or would there be another way to diminish this overrepresentation, which of course is not a good thing? Answer. I think that with this bill, we're attacking symptoms of a very worrying situation, that is a difficult socioeconomic situation of certain groups. I don't think we're meeting our objectives by taking serious crimes lightly. Criminals deserve harsh sentences. And so we do have a concern here. We think that money should instead be invested in housing, health, and other support services rather than attacking the symptoms instead of the source of a problem. Question: are there more arrests in your police service? Are there more arrests of Indigenous and other racialized people in your police service than other people? Answer: well, in Laval, there are very few Indigenous people. I could say that for some types of crimes, gang-related, for example, minorities are indeed overrepresented. How do you explain that? Answer: well, I think work needs to be done on prevention, on social development, on helping marginalized groups in society. Those would be solutions that we need very far-ranging solutions for problems that have existed for years. It's not simply by lightning sentences that will. Thank you.
Thank you. Thank you, Mr. Rochette. Thank you, Monsieur Fortin, and to Mr. Garrison for 2 minutes.
Thank you very much, Chair. I'd like to go back to Ms. Latimer. In your introductory remarks, you talked about the provisions to provide increased use of cautions, warnings, and referrals, and a concern that we needed to, if I understood you correctly, monitor that discretion to make sure that it's not being used in ways that would actually disadvantage members of minorities. Can you say a little more about that?
Yeah, I think that's a crucial thing to do. If to some extent the overrepresentation of certain groups is being informed by bias, if subliminal or objective bias, when you give discretion into the system, you may well see more rather than less of that happening. So I think it needs to be coupled with a strong, educational component about what you're intending to achieve with this discretion, and monitoring of the discretion to see whether or not racial minorities are the beneficiaries of these particular measures.
Thank you to you, Ms. Latimer, for being here today, and the John Howard Society for all the great work that you do, and I'll conclude there, Mr. Chair.
Thank you. Thank you, Mr. Garrison. Thank you to all the witnesses today. That concludes our meeting, and I will otherwise see you all on Tuesday, and have a good weekend and stay safe. Bye-bye.